Well, a couple things before the court today. One was just sort of the schedule to have. It's our belief that the statute of limitations issue that we had raised before with the court should be disposed of before everything else. This case, as you guys know, goes back to as early as 1990. There are 14 different criminal charges alleged here. Of those, statute of limitations motion, we believe, if it was successful, would dispose of 11 of those 14 charges. 306 of the 449 counts. So we've asked the court to at least hear that first, and that was on tap today. In addition was the bill of particulars, which it's a legal term basically that the defendant has a right to be put on notice as to the dates that the charges alleged to have occurred, which feeds into the statute of limitations motion. So for example, if they allege that Mr. Reed took an item in January of 2010 and they didn't charge this until July of 2015, we have a right to know the date that that act supposedly occurred. If they charge that he committed another offense back in 2003 and they just give the date or a few month range, we have the right to have some specificity on that. So the court ultimately ordered the Commonwealth to provide an answer to our bill of particulars, which I think will be everything we know about the dates is in the discovery that has been provided.
So, I mean, the Commonwealth's perspective on this is that the bill of particulars, while very commonly used in the federal system, is not a common practice within the state system anymore. And we've provided a voluminous amount of discovery, and within that discovery are many of the answers that he wants, certainly outside of any legal argument, which would come on a different day.
Just real quick on that, A.G. King said on the statute of limitations that this is the state's version of a RICO case, therefore that would imply the statute of limitations don't expire?
Well, there's a lot more to it than that, and it would all be spelled out at the time that we file our answer to their omnibus pretrial motion.
But what you did say in court today about the no new facts, in other words, for what the things that supposedly occurred in January 2010, the state has no new facts to extend the statute. It's a legal argument at that point about how to read the statute. Is that correct?
Right. Well, and I think facts is referring to the evidence that has been turned over in discovery. So what the court and what myself were saying at that point in time was there haven't been new information that's been uncovered since our ongoing investigation that has come to light. Everything that we know is being turned over in discovery.
Right. That would put it on a factual basis within the statute. Like, for example, I don't know, he did something with something stolen, or within a shorter period of time before that.
And all of that is included both in the presentment